apprehension when we last appeared has been accordingly amended to reflect criminal case number 38, anti-corruption criminal case number 38 of 2018.
The orders were issued yesterday. The orders were issued on Wednesday.
The orders were issued on Wednesday, on the 29th of August 2018. I think a copy is in the court file. We have served the prosecution, but we have made available a copy of the order for them to interrogate our own copy. So in those circumstances, we still pray that these proceedings be now stayed accordingly.
Yes, Mary, please, Your Honor. We have been served with the order, and although paragraph 5 is still not correct, it refers to a petitioner in AACC criminal case number 38 of 2018. The petitioner should be in the High Court, and the Chief Magistrate's Court is the accused person of ACC number 38 of 2018. It refers to the petitioner should be referenced to the High Court, and if it's supposed to refer to the Chief Magistrate's Court, it should be an accused person of ACC number 38 of 2018. But the order is an order of stay against the petitioner. The case against the petitioner. But we have this to say, Your Honor. We are grateful that you accorded us an opportunity to appear before you. And although this matter has invoked a lot of resources, both on the part of the investigators and the prosecutors, but also on the part of the accused persons. Because as you can see, the first accused person is represented by 34 lawyers, amongst them senior counsel, 4 senators and several MPs, former vice president, and an entity feeder which has got over 1,000 members. The second accused person is represented by 9 advocates, total 44 advocates. And it is the right of the accused person to be represented by advocates of her choice. And the point I want to bring home, Your Honor, is that the accused person was given an opportunity with all the lawyers to address the court. One, each one of them, by right, has audience before you with no time limits. Secondly, they had the right to make as many applications as they wished without time limits. And that is their right, we are not complaining. And thirdly, now on behalf of the first accused person, we have been served with an order of stay. And stating these points because the senators who are appearing for the accused person represent us, the MPs represent us, all of us. And although they are on the other side, in another capacity, they still represent us. And we appear before them time and again in Parliament and in the Senate as the Office of the Director of Public Prosecutions to account for our mandate. I am grateful for this case because they have lived the experience to see the difficulties and the challenges prosecutors face in prosecuting high-profile cases. And when we say that the cases are not moving, it's not because of us. It is our law, it is our constitution, which we must abide by. The Office of the Director of Public Prosecutions came ready to proceed. But the Director of Public Prosecutions has directed me to convey to the court his commitment to obey court orders, and secondly, to continually and always uphold, protect, and promote the rights of the accused persons, to act in the public interest, not to abuse the process of the court, and to uphold the rule of law. And finally, the Director of Public Prosecutions has also directed me to convey to the court his commitment to uphold the rights of the victims, who are also represented by the same senators and MPs that are in court today. And victims are now active participants in any criminal trial. And whichever decision we make, we must make sure that we have them at the back of our minds. With those few remarks, Your Honor, I leave it to you, save for noting that these orders do not apply to the second accused person, and therefore you'll direct us on how to deal with the second accused person. Thank you.
Your Honor, will want to make a brief reply to what my learned friend Dr. Suduru has said. But before I do it, I defer to my learned colleague in respect of the second accused person.
Yes, Your Honor.
That is Mr. Kimuli?
Yes, Kimuli. Not Kimilu, Kimuli.
Kimuli.
Kimuli, with an M-U-L-I.
The second accused?
Yes, Your Honor. Your Honor, I must thank my learned friend, counsel for the prosecution, for the statement she makes in court this morning. It is intended to confirm that the DPP is keen on acting in the interest of the public and in protection of the rule of law.
You should finish with the order. Finish with the order.
Your Honor, I can only hope that, as the good book says, he shall be a man of his word and actions, not just mere words. The Bible says we shall know them by their actions. Where I know my learned friend, she's a believer. That said, Your Honor, the question of the second accused person has been raised. And it is indeed true that the order that was brought to the attention of the court on 29 did not expressly appear to refer to the second accused person. And while on our side, we were persuaded that that order was sufficient to stay the entirety of these proceedings, we nevertheless moved to the High Court to seek some clarifications with an application seeking to apply the orders of 29th to the second accused person. And this morning, Your Honor, we have appeared before Honorable Mr. Justice Chacha Mwita. The prosecution, though served, the DPP, though served, was absent, but the state was represented by the Attorney General. And we had the honorable presence of Senior Counsel, Mr. Omogeni. I can confirm, Your Honor, that the High Court has issued an order also staying proceedings with respect to the second accused person. That order is, as I stand here, Your Honor, being extracted. And therefore, with respect to the existence of that order, I speak to you from the bar. And I hope my learned friend, Senior Counsel, can confirm that. The judge indeed stated that there is no way proceedings against the second accused person can be undertaken in the circumstances of the charge sheet before the court and the substratum of the complaints. The judge said it would be an absurdity. So, Your Honor, I hope the prosecution can take my word for it. If not so, I would request that we take an adjournment for a few minutes. If we say that, we shall believe when we see. So that the court can satisfy itself that that order exists. But even from a casual look at the charge sheet, Your Honor, even without the order from the High Court, I believe with the experience of this court, the obvious consequence of an order staying proceedings against one party would be that the second accused person may not also be called upon to answer the charge sheet. Yes, and
the orders of the court must be precise. It is possible that you could have, and we have that experience, you could have a case having 10 or so accused persons, and you find that the case is stayed against one or two, and the other people are also proceeding with their case. So it is not a must. It doesn't follow that if one of you obtains an order of stay, it applies to all the accused persons. You must read the order as it is.
That is all right, Your Honor, and I'm appropriately guided. What the High Court says in these circumstances is that if the case against the second accused person proceeded...
Sorry, Your Honor, may I speak? Which High Court and where? He's not telling us which High Court, which judge and where, and with what. He's speaking for the judge.
Well, now,
I do not need to respond to that, Your Honor. That's where I started.
I think we need to avoid the drama. It's not necessary. I didn't understand Mrs. Dorcas Odwar. There is part of your submissions that I didn't understand. And I would beg that you clarify this because it has not come out well. I would like you to at least clarify this. You talked about the court giving, is it the defense or, let me get it. You talked about the court giving a lot of time to the, what did you say? What did you say?
An accused person has a right to be represented by advocates and advocate or advocates.
Okay, let me get it clearly so that my mind is clear about that submission.
I said an accused person has a right to be represented by an advocate or advocates of the accused person's choice. And this advocate has a right.
Let's move slowly so that they can get the gist of your submission on that. So accused has a right to be represented
by an advocate or advocates of the accused person's choice.
Yes, proceed.
Whichever number, and when they are in court, they have a right to address the court. And they have no time limits, which is a right. And I said in this case we had 44 lawyers, including one entity. And one entity with over 1,000 members. And all of them have a right to be heard. And the gist of my submission was that when we appear before our good senators, they should know that we have no control of the court processes and the length of time that they take. As much as we try to facilitate the expedition of cases, we have to succumb to due process. And if due process demands that 50, 40 advocates address the court, that is what will happen. And that is why I made that submission.
Now, it is true, the accused had 44 advocates, and some of them were senators, others are MPs. How many of those advocates addressed the court?
A few of them addressed the court, and my submission is that all of them, if they wanted to, they have a right to address the court. There were?
Exactly. There are only 3 advocates.
There were 3 in this circumstance.
Addressed
yes,
the court.
Yes,
And then the second accused, on the part of the second accused, whom you said had 9 advocates, only
yes.
one advocate addressed the court.
That is true. Correct.
Yes. So I do not understand you to mean that.
No. I said in the normal circumstances, if they would have asked, and just to demonstrate how the criminal process works, if they would have requested to be heard, you would have to accord them opportunity to be heard.
Well, I think that is now why the court sometimes calls for time management, because I don't think it would be practical that all the 44 accused persons, all the 44 advocates address the court on the same issue. I don't think that is possible. So I don't think that is why I wanted to understand why you are raising the issue of the 44 advocates. Yet what I know is that in spite of that high number, only 3 advocates on the part of the first accused addressed the court. The second accused, only 1 advocate spoke. And before we could get to the stage, so that I could also know how many advocates from your end would address the court, the issue of this high court order came in and the proceedings were stopped. So I don't know whether you are trying to say that the court was according and limited time to the other side and denying the same to the state. I think if we had reached your time or your chance, definitely I would have put the question to you, how many, like I put the question to Honorable Rengo, how many from your side would you like to address the court? The only thing that the court would do is to limit the time that I would give. If I give the defense 20 minutes, or if the defense took 20 minutes, I'd also accord the prosecution 20 minutes. I think that one should be understood. And the fact that one has so many advocates coming to court, it doesn't mean that all of them will be given audience, because this is not the only case that the court is doing. The court is doing many other matters, and it has also to do justice to those other matters. So I think on that understanding, we should be clear that we should not look at it like because you have so many advocates, you'll be getting so much time. No, the court can always control that. So it's not true that we can give 44 advocates an opportunity to address the court on the same point. I think that is not the proper thing you take out of these proceedings.
I'm properly guided.
Yes.
It was in keeping. I thought you were very organized.
I think that's enough. Well, there is an issue which has been raised here with regard to the second accused. And I don't want to keep on mentioning this matter. I wanted to make one ruling which would apply after I've read the order. I do not know how much time Mr. Kimuli will be seeking for you to bring that order, because without the order, I cannot make any orders with regard to your client. If you say that, and I take your word from the bar, I believe you are an officer of the court, and you would not be deliberately be misleading the court. Yes. If I take your word from where you stand,
Yes.
You should be able now to give me that order in the next how many minutes?
Well, I think in the next 30 minutes, it should be...
30 minutes, it will be ready.
It will be ready.
You are sure the judge has already given the order?
Yes, the judge has given the order. My learned friend, senior counsel, was there. Yes, we have the order.
So I do not want to, since this is one case, I do not want to have two sets of rulings. I would rather make my decision with regard to this order after I have seen that order that you say has actually been granted and is only awaiting extraction. So I think with that, we shall take a break of the 30 minutes. We come back. If it will not be there, then I'll make an order with regard to what is before me. But doctors, you also said about, you talked about the clarity of the order. What did you say about that order?
No, I just said maybe it was also, I don't know whether to, paragraph 5.
It refers to?
Petitioner in ACC criminal case, but the petitioner is in the High Court. When we refer to the petitioner in the High Court in ACC criminal case here is a different person. Here she's not a petitioner.
These orders. Who is this? How?
I think my learned colleague should
Let me read it well so that I see the concern.
My Lord, I think if I could assist the court and my learned colleague, read the order as a whole.
I will.
The petitioner
In
is the the petitioner in the petition before the High Court.
English words don't change. It is in paragraph 5. May I read? I have to sit it.
Criminal proceedings against the petitioner.
Dorcas, what is your issue?
That an interim conservatory order be and is hereby granted staying criminal proceedings against petitioner in ACC criminal case. Petitioner is not in ACC criminal case. Petitioner is in the petition in the High Court.
Correct.
In ACC, the person is the accused person. Just that. It cannot be petitioner in ACC criminal case. Petitioner in High Court, whatever, constitutional application or whatever.
So your bone of contention is reference to the accused as a petitioner?
In this court?
Yes.
She's not.
What I'm telling my learned colleague to understand.
The word accused.
Okay, let us look at this order more clearly. Yes, Mr.
Your Honor.
Yes.
The landed friend for the state,
Yes.
Ms. Dorcas Oduor,
Yes.
she just expressed a concern, but she has no problem with the order. She has no problem with the order.
Yes.
So, Your Honor, instead of going into semantics, I would pray.
But I think the concern she's expressing is in order, because I would think that when you are extracting an order that you want to be acted upon, please let's be precise. You know, they are not mere sideshows. Let's look at it from that angle.
Yes.
It's good to have something that is clear,
Yes.
and something that is explicit. Because now, you see, when you refer to, and you know very well, senior counsel, when you refer to somebody appearing before me as a petitioner, I would rather even if it had actually been the applicant in the High Court case. But it's okay, I understand.
Yeah, this is.
I understand.
And for that, I'm grateful to her. She actually told
She has
me.
very sharp eyes, I agree.
Yes. Yeah.
She is able to note
So I think it'd be good on the basis of what she has said to me and told the court that she was just expressing concern.
That's okay. That's in order.
Then, you know, the proceedings now as against the.
Let us give Mr. Kimilu time to give us.
Kimuli, Your Honor.
Yeah.
Mr. Kimili time. Kimuli
Yeah.
to extract the orders if he says that they are there as for the second accused, so that we combine the two and we see the way forward.
I think it was
Just
very
that.
complicated.
So we can resume after how many minutes? Why should extracting an order take that long? You can resume at 12. We have 20 minutes.
If you can be able to get the court file, Your Honor, I'm really praying because, you know, today is a Friday and we've got other matters in
The
court.
extraction is not done by the judge, it's done by the DR, isn't it?
Yeah.
Yeah, and I'm sure any of the DRs can do the extraction. I'll bring the order. In 20 minutes should be ready. Because it is going to be modeled on the order that is already before the court.
Sometimes getting orders from courts
No, it's
take
not difficult.
faster than.
Let's get
but let's. Can we say that as soon as we get it?
Yes, as soon as you get it, I'll be in chambers.
Yes.
I'll be able to come back and make the necessary directions in view of the orders.
Much obliged. And when we come back, there's only one small point that I'd want to address the court on the issue that my learned friend talked about. But let me leave it for now.
Okay, let's meet in 20 minutes time at most.
Okay.